Hi, this is Curt, and welcome to another edition of Fire Law Roundup.
Go ahead, take us away.
I don't even know how to start. Let's go to Washington. Let's go to DC. And there's a lawsuit. Normally, we don't prejudge the truth of the facts because we don't know. They're just allegations. Here, however, we have an arrest and a conviction, presumably based on what happened. So I'll go. This is a little long, but let me do it anyway. And this is a really interesting and pathetically probably more true than not story. So here we have a female firefighter. She's suing for a couple of things, and I'll go through it. But she's in federal court, and she's suing alleging violations of Title VII and the DC Human Rights Act, which I presume she can do in federal court as a tag-along claim. And she's also suing over retaliation. Frankly, if it was me, I would have added in Family Medical Leave Act, which as well as some other
always
things.
Find a way to work that in there.
We do. But that was the point, that FMLA, for the knowledgeable attorney adds you a lot. So I'll go through the facts, not quickly, just through the facts. So in 2020, she alleges that during a night shift, a lieutenant walked in, walked into her bunk room, and in short says, listen, somebody needs to see you. I didn't totally get this. You're being relieved of duty. But nonetheless, he then sticks his hand, he leaves, comes back a little bit later, sticks his hand down her shirt and grabs her, and then apparently somehow stuck a $20 bill in her.
It's 40 total.
Oh, okay, 40 total. And sticks money in her shirt, bra. I'm not sure. I like that the complaint says she felt uncomfortable. That would be an understatement for me. She expresses to him that she felt uncomfortable. He says he's allegedly said something like, it makes comments back like, oh, you didn't leave this. And he's making these strange comments, but in any event, he gropes her unwantingly. I would say that's assault, if not a battery, but nonetheless, she then complains about it. Now, this, if true, is also extremely shocking because she reports it. She both goes to the police, kudos to her and whoever's advising her, 2 days later or so, but that's not uncommon for people to wait and contemplate rather than run right to the police.
And process what happened, right?
Yeah, and a lot of lawyers like to say, oh, you didn't go for 2 days. That's pretty soon to go to the police. She fills out the police report. She then tells the department. The department, this is a little confusing, sends her to somebody
very confusing, yeah.
Right, maybe wasn't the right person who was supposed to be addressing it, but she was told it was. She reports it, and she reports that she's been sexually harassed. I hope also said and physically abused. And nonetheless, what's striking to me about these allegations is the department says, well, because it's being investigated by the police, we're not getting involved. Which I understand that line of thinking. I have said that as part of a long series of other actions we're going to take, like making sure you never see this person. Maybe the charges here are so serious, right, that he should have been relieved of duty. The groper immediately sent home. Hey, fine, with pay as we investigate. I do understand not conducting a full investigation, but here, right, because the police are investigating, but at least take the darn statement from her, and that's enough to say you're not going to work together. Nonetheless, she asked for 2 days off. This is my FMLA claim. She asked for time off because of the traumatic stress, allegedly. They give her only 2 days. That's why I say that's a violation of Family Medical Leave Act, unquestionably. Nonetheless, she didn't raise that, but she is then forced he's not removed from the firehouse, right? And as we said on the last time, there's no secrets in the firehouse. This is all going around, right? People have allegedly commented that they've heard about it, they know about it, and state everybody's talking about it. And basically nothing really happens for a while. The guy's still working in the firehouse. See my eyes of amazement here. She's encountering him. She continues to say, I'm uncomfortable and don't feel, I fear for my physical safety, she said. At that point, we got a violation of the workplace violence statute, right? And I agree, this is also workplace violence. I would have added so much to this lawsuit, nonetheless. But, and he keeps remaining on duty. That really sums it up, except the big kicker is, I don't get this either. So in June of 22, the lieutenant's convicted of sex abuse in DC Superior Court. He's sentenced to 120 days of incarceration, but of course nobody goes to jail anymore unless you murder somebody. So the sentence was suspended. The court ordered a $50 fee, and he would be on supervised, I think in-house or something, probation. I don't know. He was in-house for a little bit, but he's on probation for 12 months.
Yeah.
What I didn't see is, as a result of that, did he lose his job?
We haven't been able to document that. I didn't see anything in there. I would have thought that would have been in the complaint. There was something about 30 days after the incident happened that the department did something, but it was a little ambiguous. But, there's a part of this that we got to wrestle with. We have a little bit of a bureaucracy in bigger fire departments, okay? And she went initially to her company officer. So, I'm assuming it was a lieutenant that she went to. So any supervisor, when they become aware of an allegation of sexual harassment or sexual assault, it's the same as if the fire chief, it's the same as if the mayor, they're a supervisor.
Right.
He apparently did some diligence, but he may have sent her to the wrong person for an EEO complaint. Now, that still doesn't explain why some of the other people that became aware of it didn't send it to the right place. And like, oh, well, we're not going to investigate because you didn't come to the right person, or we're not going to handle this properly. You've got to go talk to. So this isn't like a football that you can hand off to somebody else and now they get to run with it.
Right.
You're aware of it. And now that you're under a duty of due diligence to properly handle it, to properly report it, and it just doesn't look like it was done. Now, this is her allegation. We don't, but
the sentencing gives some credibility to it. But just to add on one thing they said, because it was a lieutenant who allegedly did this to her, DC loses, right? When a supervisor is the harasser, you lose. I don't agree with this rule, but it's the law. The employer is deemed to know what the supervisors do. He's a supervisor. And he's a supervisor. They lose. So the only question is, how badly do you want to lose? Had they sent him home, taken care of her, gotten her counseling, and addressed the situation right off the bat, we probably wouldn't have a lawsuit because she wouldn't have felt dismissed and violated and embarrassed, right? If this is true, this was an incredible, incompetent reaction to this. Total failure. Whoever was part of this should be ashamed of themselves if it's all true.
Right. I got a question for you. And I meant to research this myself, but maybe you're familiar with it. Under federal law, under Title VII, you have to make a claim within 180 days unless your jurisdiction has adopted, some additional parameters, which then it extends out to 300 days. So if we assume that she's got 300 days and she didn't file the EEO complaint properly, because she was misled, that would be sort of one defense. I think that's one. The other one, and I know in many firefighter Bill of Rights states, there's time frames that you have to file charges within so many days for a Bill of Rights disciplinary violation, but they're typically suspended. Those time frames are suspended when there's a possible criminal act, to give the criminal process time. Do you know off the top of your head whether or not the 300-day running for the EEOC complaint is told when there's the possibility of a criminal offense?
I don't know on the criminal. I can answer the first part, which was about her being misled. I don't know on the criminal if it's told. And I just read a number of cases, a little bit different, that when you file a challenge to an administrative action, in New York at least, and went to New York State's highest court, if you failed to raise parallel causes of action at the same time, they would dismiss the ability, right? If you missed it, they would dismiss it because you didn't file both together, and you could have. This is kind of along the same lines. Now let's talk about the first. I think it's a fair question. I think it should toll, but I've not seen it toll for criminal, and I've had a number of these cases on the defense side. What I do believe would toll it, however, is because I was just involved in a case with tolling based on misrepresentations of a, in this case, a fire district, but an agency, a government agency. The courts will toll when you relied on that. When you relied on this statement. So if somebody said, hey, we're filing this for you, or we're taking proper action, and you had a good faith belief, and here's the kicker, the action they said they took would have had to delay, right, your ability to file, or would have had to give you extra time. Frankly, as long as they're investigating, it's told, right? The statute doesn't, or the time to file doesn't run because nothing bad or good has happened to you yet. You haven't been discriminated against because they haven't said you lose. I mean, once they render a final decision. So what I'm looking for is, when does it start to accrue? When did she receive a decision that would start the 300 days? Just from what we have at the moment, I couldn't.
Well, no, it starts the day that she was assaulted. That's when the 300 days starts.
I'm not so sure that it's because the allegation she's claiming is not just that she's assaulted. It's that nothing happened to cure it.
That can be this. That's the retaliation, and that's got a separate. Right. Each of those acts could potentially have a separate 300-day total. But this is different too. And you think about, for example, let me use my own fire department, the Providence Fire Department. If someone filed a complaint, it's not going to be filed with the city of Providence. It's going to be filed with the Rhode Island Human Relations Commission or the EEOC,
right? Because
they are the appropriate party. In the District of Columbia, is the appropriate party because it's not right. You think about it. So that complicates this, and you could almost argue that complaint to that initial lieutenant was the equivalent of an EEOC complaint. Now, I don't know enough about the ins and outs of the administrative procedure in DC, right. But there's an awful lot, to chew on here in this case, to think about. And
and one of the things we should highlight or repeat, because we've said it, right? If people are looking for the lessons in these, these things go right to the top, right?
Absolutely.
You don't leave them with another lieutenant or a cap. Come on, right? You're talking about sexual assault resulting in a police matter. But look, you've got workplace violence issues. You got family medical leave and post-traumatic stress issues. You've got all sorts of different issues that have gone on. And if you don't get this to the highest level and make sure it's being taken care of at the highest level, it's not going to go well for you. So that's how you don't react like this, right? Allegedly, right? On these alleged and
tough situation. But again, just to kind of go through the bureaucracy here, it looks like there was some confusion between a line officer being notified, and then apparently internal affairs got notified. But both of those are separate from an EEOC complaint,
right?
And really, I think what is important in this case is that the EEOC complaint gets filed as well, because that's the one that's got to be filed within 300 days in order to protect or preserve those Title VII rights.
Right. And agree. She's got all sorts of other avenues if on the underlying assault, right, there's not sufficient action. I think she could get around it different ways. I have a hard time believing a judge is not going to side with them saying, listen, you were greatly misled by what was happening here. I don't understand that, you know, the EEO person not being the right person. How do you take a statement and be like, what am I doing here? Right?
If I'm an internal affairs investigator or in charge of internal affairs and somebody comes to me with those claims, I'm not just going to keep it. I've got to advance those to the proper people. I mean, that's
right. And you know, one other thing I should mention, you will never go wrong. Look, you and I draft policies that outline your rights and remedies for everything, including sexual harassment, all right, and sexual assaults, any sexual inappropriate behavior. Mm-hmm. The best thing anyone can do, in addition to investigating everything else, is hand them your policy, which hopefully outlines all of their rights. So you can say, what did I advise them? I advised them, here's the policy, as opposed to you, a lieutenant or whoever, interpreting what you think should be said and what rights there are and maybe not covering. Hand them the darn policy, right? Much easier.